Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, and holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Hello, Christopher Engelby. Christopher says, hello, sexy people. Hello, hello, hello. How's everybody doing? Better than me? I would almost guarantee that you are. That you are. I hope everybody is seriously doing better than me today. But today we have before us a tale as old as time. A man who has said he was going to do something and then he didn't fucking do it. Now, I apologize to all those men out there who do the things that they say they're going to do. But this man is a little different. But some of you may know him from court, of course, because we've seen him before. About a month ago, he was sentenced to jail because he would not sell his motorcycle to pay, was it spousal support? I think it was spousal support. And Judge Grumpy Pants certainly took umbrage with this, I would say. Do you think J.K. Rowling did that? Aww. Chris, you're so sweet. I love you. Thank you so much. Do. I love your positivity. It's almost contagious. Seriously, that's so sweet. Anyways, so this guy that I'm talking about, definitely not Christopher Engelby. Oh, I like that color combo though. That purple, isn't that very like 1998? That purple and green color. Think doctor's office. Think whatever. Anyways, I know J.K. Rowling has all that stuff about her, but remember Professor Umbridge was a bitch. And Umbridge, doesn't that mean sort of like persnickety or like problematic? Anyways, I don't know. I do like purple and green as well. I do. They look really great together. You got glasses? Oh, Vicky, you're right, honey. I did. I'm so sorry. It's because when it happens before I'm here, it goes to the top. Give me 1 second. Where is it? Here it is. Thank you, Vicky. Let me get your thank you. Vicky, seriously, thank you so much. I love your support and I love your comments. They're so sweet to wake up to in the morning. I really appreciate it. And thank you for your support. Christopher, you got new glasses today. Would love to hear about that. How are they feeling? Taco Bell in the 90s, Joey. Yes, there we go. That's what I'm talking about. Okay. Guys, it's Tuesday. Impeccable timing we all have, don't we? Impeccable. Oh, Beverly. This too shall pass. If you say so, girl. If you say so. But you guys, he did not pay for his motorcycle, or he did not end up selling his motorcycle. So let's go off to Bronlick's court and see what happened, shall we? If I was a better YouTuber, I would have prepared the other video, but I'm not, so I didn't. but I did get this one. Vicky has become a member. In fact, it's been like 11 months. But she says I'm the bomb. Thank you, Vicky. I love you, honey. Very sweet. So we're here. And we're gonna...
listing price of it.
Judge, make your entrance.
Calling the matter of Sarah Thomas versus David Albin.
For the record, this matter is before the court for post-judgment review of the status of the defendant's efforts to sell a motorcycle and reduce outstanding spouses board arrearages. This hearing is being conducted via Zoom. Present the parties, Sarah Thomas and David Albin, as well as Minocqua Front of the Court Attorney Rebecca Hicks. Good morning, Ms. Hicks. Ms.
Morning, Your Honor.
Mr. Albin, Ms. Thomas. Ms. Hicks, have you had a chance to discuss these issues with the parties?
I have, Your Honor, and I did review the file to see that Mr. Albin has submitted additional documentation to his friend of the court caseworker regarding taking the motorcycle to multiple dealerships to try and get offers on it. He received 3 actual, I guess, cash offers, and the rest were only offering him like a trade-in value. They wouldn't offer him any cash value for that. And he also has it listed and lowered the listing price of it to just over what his total arrears are, and provided that.
Okay. What is the highest cash offer, Ms. Hicks?
$8,500.
Okay, is Mr. Albin making any payments toward the?
Yes, after being released from the 30 days in jail, he did, they did give him his job back, and we do have an active income withholding notice to that employer.
Yay, Christopher, putting a smile on my face. Thank you. And Shane, I bet there's a smile on your face too. Yay!
What's the amount of the outstanding arrearages?
The total balance right now of the arrears on this case file are $11,530.92.
And they're being reduced per month by how much?
The income withholding notice has gone out for $351 based on the statutory limits on his case.
Right. So since we were last in court back in August, the arrears have only been reduced by $350. The arrears were $11,800 back then.
He served 30 days in jail, Your Honor, and he just started resuming work.
All right, I understand now. All right, you have a recommendation for the court this morning, Ms. Hicks?
Your Honor, I did inquire, and Mr. Albin admitted that he's been driving the motorcycle. I do believe he should not be driving it, as it would be the position of the friend of the court that would diminish its value with each mile that is added onto its current mileage. The friend of the court would not be opposed to a short adjournment to allow him to pursue actually selling the bike to potentially one of these people that offered it, or see if he.
So he's riding the bike still. Ugh, typical man, playing both fields. Chris, I haven't made him yet. Hi, Bob. And I'm glad to hear about all your dinners. That's so nice. That's so nice. I'm having coffee. That's gonna be my dinner.
He can get an offer for the lower amount that he sold it for.
All right. All right, the court here from the parties. Ms. Atkins, we'll hear from you first.
All right, thank you so much. Yeah, I think that's a good recommendation. He does drive the motorcycle. I've seen him driving it through town. I've seen it parked at his job before. So, I think, yeah, he shouldn't be driving it anymore also.
All right. Any objection to a short adjournment of this matter?
No.
All right. All right, Mr. Albin, again, obviously this is pretty significant rarity. It's still $11,500. You should not be driving the vehicle. Why should this court not order you to sell it for $8,500? You got an offer, a cash offer for that.
Your Honor, the bike is Blue Book value is around 14 with only 11,000 trade-in. $8,500 seems a little low. I mean, I understand they're in the business to make money. I just thought if I got to take like $4,000 or $5,000 less than what the bike is actually worth, is there any way that Sarah could maybe lower what is owed to her by a little bit just to kind of counterbalance the. So I did lower the bike to 12,000 stuff, 2,000 less than Blue Book. Fox is selling the same Fox and Sandusky is selling the same motorcycle with 5,000 more miles on it for 14,000. So I lowered this bike to 12,000. That would seem like a fair price according to Brian at the Motown Harley.
Are you advertising on Facebook and other media sources?
Yes, Your Honor.
Well, again, obviously the time sell is in the summertime, and here we're going into October, so obviously no one's people are not going to get the top dollar for a motorcycle in the month of October and November. Mr. Albin, do you have another vehicle that you can go to and from work with?
Yes.
Okay. Again, convince this court that you should not have to sell for $8,500, and you can sell it this week.
Convince the court that I'm making payments.
That's not the question, sir. But you're not. Again, you're only reducing wages by $300 a month.
I think that's every 2 weeks, and I think $116 deductions. I have another case that I only owe like $2,600 more dollars on, as far as that, and then I still owe state owed arrears.
Well, this court's not a collection agent, Mr. Albin. Ms. Six, again, there's no way this court, even if court orders Mr. Albin not to operate it, there's no way this court can monitor that.
Okay, I'm lost for words, Your Honor.
Well, Mr. Albin, again, you get 30 days in jail. You didn't do what the court wanted in the past. I'm really tired of dealing with this matter. Again, the sixth way to do it is sell it for $8,500. And you put that right toward the rearages. Why? You need to convince this court that should not be ordered this morning, Mr. Albin. Unless Mr. Atkins says, Judge, hold off. That's what the court's inclined to do.
I since like 2019, I've been given consistent payments other than when I lost my job at Circle K and went to another job. I've tried not to miss any payments up until, I think it was December, January last year of 23. And then I've been trying to make consistent payments at 116 a week since like 2018, 2019. And then
Mr. Albin, but going back, of course, you sold an asset and you generated significant cash, and you went out and spent it or hid it or bought a motorcycle rather than pay your arrearages. Ms. Atkins, do you want to ask this court to give Mr. Albin more time, or do you want it sold and liquidated this week?
I would like it sold and liquidated, honestly. Yeah. It's just been so long, so.
Court agrees. It's going on too long, and Ms. Hicks, the court will order that Mr. Albin sell that vehicle forthwith. I'm gonna have you come back in 2 weeks, Mr. Albin, and I expect you will have paid I want to see a sales receipt, and that entire proceeds will be paid to the front of the court towards the arrearages. So I'm gonna put it off for 2 weeks. You're ordered to sell the motorcycle for the best you can do, and that's it. Whether it's 8,500, 8,000, 9,000, you got 2 weeks to sell it. And then the court can order that to be sold. And if you don't, we're gonna start contempt proceedings when you come back in 2 weeks. If it's not been sold, you've not provided a copy of the sales receipt and paid 100% of that to the arrearages. Have a date. We're gonna put this back on the court's docket. It's not gonna be worth any more come spring. And there's no way the court can monitor Mr. Albin parking this vehicle and put it in storage.
Oh, there's Mayor himself. Mayor, glad to see you. And Drunk Beaver Productions is here too. Oh, homemade bean soup and muffins for dinner. Sounds good, you guys. Sorry. Distracted by something on my phone. Checking something quickly. Casey Carey's here. Do. Thank you, Casey Carey. You guys, I love y'all. Don't rub your face, Paisley. Your makeup will smudge and it'll suck. But I want to rub my face. Anyways, let's continue, shall we? But Mayor, we're sending you good vibes, Mayor.
November 15th. Did you say that?
No, I said 11/5.
Oh.
You went further out.
Yeah.
You said 2 weeks.
We give him 3 weeks. Yeah.
So then we can do 11, 12 at 9:30.
How about November 12th at 9:30?
Okay.
I'll give you 3 weeks, Mr. Albin.
Okay, thank you, Your Honor.
Does that
All
work
right.
with your schedule, Ms. Six?
Yes, absolutely, Your Honor.
Okay, so this matter is adjourned to November 12th at 9:30 via Zoom. Ms. Six, is it possible you could prepare an order for the court?
I will, Your Honor, and I'll make sure to include your Zoom ID on it.
Okay, thank you. So the party, the matter should come back before the court for review November 12th at 9:30. In the interim, Mr. Albin is ordered to sell the motorcycle in question and provide it to the front of the court before November 12th, the receipt showing the proceeds received and from who purchased the vehicle and name and address of the purchaser, Mr. Albin. And the court would expect that 100% of those proceeds will be applied toward these rearages.
Yes, Your Honor.
You get more than 8,500, but then if you don't do that, then the court's going to start contempt proceedings. Which will be punished by up to 45 days in jail at that time, and we'll at that time appoint an attorney to represent you and go from there. Any questions, Mr. Albin?
No, Your Honor.
Right, Ms. Atkins, any questions?
No, Your Honor.
Okay, I presume everyone still has the same address because copies are already mailed out to each of you. Ms. Atkins has confidence. Is that still your current mailing address, Mr. Albin?
I'm sorry, I lost you for a second on the audio. Pardon me, same address. Yes, Your Honor.
Okay, all right, the copies are already mailed to you November 12th at 9:30. All right, that will conclude this matter. We'll see everyone then.
Thank you.
Ms. Six.
I'll get that order uploaded. Thank you.
A quick Google pass tells me that it's about people profiting from their crimes. Also, I love all the hugs, guys. Thank you very much. Judge. I bet he gives good grandpa hugs, but whatever.
Make sure he increases life insurance.
I don't know. You'd want to consult a lawyer on that pass, which I
Or
am far
Tracy
from.
Bell. Oh, boy.
Full of something. That's right, Bill. Full of something. Kirsten, your fucking turtleneck's bothering me today. And Aaron, your face bothers me. And your face bothers me, but MB doesn't bother me. But Streamlabs is bothering me. Why aren't you saying what MB did? Why aren't you saying thank you, Streamlabs? It's what I literally pay you for. MB, you're amazing. You're amazing. No, you are amazing. I love the dancing pair. Oh, Attorney Fan Zhang, Wyatt Paisley, stop being mean to people unnecessarily. Okay? You need to stop it. Sorry. Hi, Tin Man. How's your, is your vacation over? Tell us some good news, Tin Man. Also, Streamlabs is the program I use to run the stream pass, so it's like the one in charge of all the sounds and shit. Vacation is over. Oh, they all end. It sucks. But I'm so glad to hear it was great. You can tell us all about it now that you're back with no safety concerns. Hi, Tony. You're so sweet. I'm not as high as I need to be. That's probably the issue right now. All right, let's let it cook, as the Gen Zers would say.
Matter of Christopher Sanders versus Aaliyah Pilcher.
Good morning.
For the record, this matter is before the court on the plaintiff's motion for the court to assume jurisdiction over the minor child in parenting time. This hearing is being conducted via Zoom. Present is Attorney Fan Zhang, representing the plaintiff, Father Christopher Sanders. Mr. Sanders is present. In addition, Attorney Christian Nimick is present, representing the defendant mother. Aaliyah Pilcher. Ms. Pilcher is present. Good morning, everyone.
Good morning, Your Honor.
Morning. Good morning.
Before we begin, court's recollection is that a stipulated order was entered by this court to register this case and for this court to assume jurisdiction. Is that not correct?
That is correct, Your Honor. But procedurally, I usually get a order regarding registration of out-of-state child custody determination from the court after it's registered, and I have not received that. So the court needed enters one in order for this case to be registered. It's the scale form CC 389.
Correct. Actually, there's one staple to the left-hand side of the file, Mr. Zhang, and there must have been a reason why the court did not sign it back then, or maybe perhaps the court was waiting for the stipulated order. And of course, the court signed it electronically. The file wasn't up here, so the court didn't see that scale form.
Okay.
But this form was completed by the clerk, indicating
Yes.
that the order issued by the Harlan County Circuit Court in Kentucky was registered in this county on May 10th, 2024. A notice of registration was dated May 10th, 2024. Respondent. And there's categories, but the respondent did request a hearing, correct?
Initially, yes, Your Honor, but so if that was May, we filed our stipulation, it looks like August 7th. So that might have been the breakdown in the procedure.
So the court needs to make findings. It gives like
I don't think we
A,
did
B, A
that.
through F. Respondent did not
Yes.
request a hearing. Respondent challenged validity of the enforcement of the order. Respondent requested hearing but failed to appear. The issuing court lacked jurisdiction to make a determination. If respondent did not receive proper notice, I suppose I could just ignore
I think-
those or X amount, just put that the court finds by stipulation that the registration is confirmed. Would that be sufficient?
I think
that would
B
be
is fine. I think you can check 3B, challenge the validity of the enforcement of the order, evidence was presented, and then make a finding that on 4.
All right. All right, that probably is the easiest.
Right, because there was a objection file, so technically there was a challenge.
Right, thank you. Yes, so that this form is in the file.
Yes.
Form CC 389, the court has signed that and that will go out.
Yes, perfect.
We
Thank you, Your
also
Honor.
need to address, the parties also address parenting time. So with that form, Ms. Brower has provided the court fine recommendation regarding parenting time. You two minor children. Fathers shall have 5 weeks of parenting time during the summer. The parties shall agree upon the dates with respect to Raleigh State cheerleading competition. Fathers shall have December 26th until the Friday before school resumed for the Christmas holiday. The parties shall rotate spring break and Thanksgiving. Mother shall have Thanksgiving 2024. Father shall have spring break 2025. Father shall have such additional parenting time in Michigan. Times the parties can agree with a minimum of 2 weeks notice. Court shall be referred to front of the court for formal investigation recommendation, with each party having 21 days in which to object, in which case come back before the court. Further, it's recommended the parties shall share equally 50-50 the cost of travel for the children. The parties shall agree that the flights booked for the children, and neither party shall modify the flight without the agreement of the other. If father's holiday parenting time is affected by the children's extracurricular activities, he shall receive makeup days during his summer parenting time. Neither party shall be blocked from any of the children's electronics. The children shall be allowed to make phone contact with both parents at any reasonable time of the day. Any modified child support shall be effective December 1, 2024. And finally, oral prior orders not inconsistent with this order shall remain in full force and effect. That is a recommendation. Mr. Zeng, is this a recommendation agree with your client?
Yes, my client is willing to accept this recommendation.
Thank you. Ms. Nemec, is this recommendation agree with your client?
It is, Your Honor.
Thank you. The council, do you wish to bar dare your respective clients?
I'm sorry, could you repeat that, sir, Your Honor?
Do you wish to bar dare your clients regarding
Yes.
this recommendation?
Yes, I do. Thank you, Your Honor. Mr. Sanders, can you speak? Can you please place your
I'm going to swear in
name?
the parties. Mr. Sanders,
Oh.
Ms. Pilcher, I don't know if we lost her. Can you both please raise your right hand to be sworn? Ms. Pilcher?
I can try to turn on my camera, but it's
That's fine. You're
lagging.
still here. You can appear by audio. Do you both
Okay.
solemnly swear affirm that the testimony you're
Okay.
about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Ms. Pilcher?
Yes, sir.
Thank you. All right, Mr. Zhang, you can begin with Mr. Sanders, please.
Okay, Mr. Sanders, can you place your name on the record?
Christopher Ray Sanders,
Can you spell that for the record?
CHRISTOPHER. Ray is spelled RAY. Sanders SANDERS.
Okay, the parties have worked with Ms. Aaron Bauer this morning regarding a settlement agreement in a recommended order. Did you listen to the settlement terms that was placed on the record by the judge?
Yes, sir.
Did you review that recommendation and settlement?
Yes, sir.
Did you understand all the terms of that recommendation and settlement?
Yes, sir.
Do you agree with all the terms of the settlement agreement and recommendation?
Yes, sir.
Do you believe that it is in the best interest of the children?
Yes, sir.
Okay, thank you, Your Honor. That's all I have.
Thank you, Mr. Zhang. Ms. Nemec, do you have any questions, first of all, for Mr. Sanders?
Yes, just a few, Your Honor. Mr. Sanders, you understand that all parenting time not specified by this order is Ms. Pilcher's parenting time, correct?
Yes, ma'am.
Okay. And with regard to the travel to and from for your parenting time, you agree that you're going to look at flights for all possible major airlines, right? Not just limit them to Southwest?
Yes, ma'am.
Okay, I have nothing further, Your Honor.
Questions for Ms. Pilcher?
Alia, can you state your name for the record?
Alia Elizabeth Pilcher.
Okay. You heard the agreement that the judge read into the record, correct?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Okay. Did you have time to discuss it with me?
Yes, ma'am.
Do you understand that we could have proceeded to an evidentiary hearing and the outcome could have been different?
Yes, ma'am.
But rather than go to evidentiary hearing, you want the court to adopt the agreement that was read into the record and make it an order of the court, correct?
Yes, ma'am.
Okay, do you believe that the agreement is in your children's best interest?
Absolutely.
I have nothing further, Your Honor.
Thank you, Mr. Mick. Mr. Zhang, do you have any questions, Ms. Pilcher?
I do not.
Well, the court would like to thank Ms. Brar for her assistance this morning, helping facilitate a resolution, as well as, of course, Attorney Zhang and Nemec. The court defines agreement between the parties being the best interest of our child. The court will only adopt the agreement, enter the order. The court has also signed the order confirming registration of the out-of-state order here in the state of Michigan. So those will all be mailed out to the parties.
Thank you, Your Honor.
All right, that will conclude this matter. Everyone zoom out. Today, Mr. Sanders, Ms. Felcher, communication is the key, so please communicate. There's enough challenges in life. Make it good for each other and your children.
Just one procedural issue, Your Honor. The attorneys will have to work together to submit a verified statement to the FOC so that child support investigation can be conducted.
Correct. I think in front of the court will actually mail out questionnaires to the parties.
That is
For the
correct.
child support
That's part
recognition.
of the investigation, but I believe that there was no verified statement or application filed with the petition, and I think that's what Mr. Zhang's talking about.
Yes, that's correct.
Okay. All right. All right, that will conclude the matter. Thank you.
Thank you, Your Honor.
Welcome.
Okay. Hi, Mayor. Look what you found. 11 whole months. You're such a stud. A gnomely stud you are. Let's continue. What do we need? Sorry, my brain's all over the place today. Back in this, oh my god. So I can't have a real job. I can't even wait through these people's fucking real job to watch them and critique them. What, are we just gonna sit and talk to each other this whole time?
Walter Lightfoot would suggest.
Go back! Pissing me off!
Just tried the sugar, the international diet sugar cookie. Like the creamer.
That's that way I'd have to drink it because it doesn't.
That's a game changer for a coffee.
Too sweet. I feel like a bag of shit.
Oh, he's been here for a half hour.
Yeah, we've been here for fucking 33 minutes, Judge.
He's here.
He's good.
Okay. All right. Okay. No one told me. Oh, the phone's Godfrey. Okay. Right. Okay. Okay.
Calling the matter Penny Doom versus William Doom.
For the record, this matter is before the court on the respondent, William Doom's motion to terminate a personal protection order. This hearing is being conducted via Zoom. Is William Doom present on audio?
Yes.
Mr. Doom?
Yes.
Okay, are you William Doom?
Yes, I am.
All right, Mr. Doom, the court file reflects that the sheriff deputy was unable to serve Penny with a copy of your motion and notice of hearing. The court file reflects an affidavit to that effect. So unless, since there's no proof of service, court has no alternative to once again deny your motion to terminate.
Ah, geez. It cost me $38 too.
Well, I see an invoice here for $12. I'm not sure we got $38, but in any event, Mr. Doom, in the court's opinion, this is a bare bone PPO. It doesn't affect you in any way or fashion. It simply says, don't assault her. And don't threaten her. That's it. This will automatically expire in September of 2025. There's no, it doesn't, does not prejudice you in any form or fashion. So you can file another motion, but again, the court's probably not inclined to grant your request because there's really no harm. There's no prejudice to you. It's a bare bone PPO. And her allegations, again, was that, and we've seen the petition. She said on September 26th, actually September 29th, that you raised your fist at her, threatening to beat her up and scaring her. And she was afraid of you hurting her. So that's sufficient for PPO. If she testifies to that, the court would probably deny your request. But in any event, you need to personally serve her with your motion notice of hearing. Are the two of you still married?
We've been married 41 years almost.
Okay. Do you still live together?
No.
Okay.
She moved in with with her daughter, the one that's causing all the problems.
Okay. Well, why don't you file a complaint for divorce?
She was supposed to do that. I don't know if she has or not.
No, she's not. I always
they
check
always
to see what's the status of the parties, and you're still married. So I mean, that's what the court suggests.
She's taking everything out of the house, Your Honor. She has removed almost 3/4 of the house that's in here. I can't do nothing about it. I just sit by and let it happen day after day. I've had the sheriff departments out here 3 or 4 times, I think.
Okay.
And they said
the court
they can't do
suggests
nothing.
Court would suggest retain an attorney. Attorney can help you and file for divorce. You can move on with your life. But at this point in time, Mr. Doom, I apologize for you waiting. We were waiting, hoping that she would appear. She did not. And once again, the court will deny your motion to terminate for the reason that there is no proof of service upon the petitioner. Do you have any questions?
Can I react to this PPO or not?
I'm sorry?
Can I make any statements for this PPO she put on me at this time?
There's no purpose served. You can make a statement if you want, but the court has no choice but to deny your motion because of lack of service. But go ahead and make a statement if you want.
Yes, I've never hit my wife in almost 41 years or even threatened her. I don't drink. I've been in the AA program for almost 14 years. Had a little relapse last year. In November, my wife went to Florida then, but she was gone for a year the time before that, living on her own in an apartment, and I never got no payment to make a house payment, so I had to hire a law firm, try to get these payments, and they done me good. I mean, it didn't help me with the payments, but they got me reduced on my what I owed on the house by $46,000. This modification that she's complaining about, I remember it happened 8-9 years ago. I don't remember signing her name. I don't remember signing my name, but I know what happened. They wouldn't deduct my $46,000 what we owed on the house. My wife was chanting that we owed $169,000. No, we owed $98,000. On account of that principal, they deducted off our loan from the bank. She's took my dog out of the car, my pit bull we had. Out of the house, and I can't see it. She won't let me see it. Bring them over, and it's really hurting me. I'm 81 years old in a month, and I can't do nothing except this PPO that somebody can put on you. It's all her daughter's fault. My stepdaughter, she caused a lot of trouble. She accused me of taking her gold out of here and melting it down, whatever. She only took gold down. It was upstairs, supposedly. I have never seen it in years. And it's just stuff like that irritates me. I know who took her gold. I do know.
All right.
He stole
That's not before the court
off of
this
me.
morning, Mr. Doom. Those are matters subject to a divorce action. This personal protection order does not prohibit contact. You can have contact with her, just don't threaten her. Don't touch her without her permission. That's all this prohibits.
I've never threatened her,
you can call her. You can take her to dinner. You can have a breakfast with her. So the court suggests these issues that you're raising, court suggests you talk to an attorney and file a divorce action.
Right.
So the court's entered an order of dismissal, denying your motion. You'll get a copy of Mr. Doom, and the court would suggest rather than spend more time and more money on trying to deal with PPO, you're better off, sir, by just filing a complaint for divorce. If that's what you choose, if that will simplify your life since you're separated, all right?
Right.
Right, right, good luck, sir. You can zoom out.
Damn, let's rehash that a little bit. And my eyes are puffy and sore. And instead of rubbing them, I'm putting the spoon on it. You don't see any puffy eyes? Oh, the magic of a camera. Ba-doom, tsh. Ba-doom, tsh. Stealing her gold? It was all that meddling kid's fault, right, Loud Elvis? I would have gotten away with it too if it weren't for those meddling kids. Pink Coke. No, thank you. No cocaine for me. Thank you very much. Not anymore.
Okay. Well, thanks a lot, Your Honor, for your time.
You're welcome, Mr. Doom.
Bye.
Bye-bye. It feels better. Sure.
Calling the matter of Troy Licata versus Michelle Licata in the.
For the record, this matter is before the court, the court's act for review. The parties have agreed, both parties represent legal counsel, they've agreed to adjourn this matter to October 20. This is October 22nd. This is an old SIP order. Okay. Do we have a new date? Oh, November 12th, right? This is the old SIP order. This adjourned to October 22nd, and but the parties have agreed to once again adjourn this matter to November 12th. Is that correct? 8:30. Okay.
I dropped my spoon.
Put this on our docket.
Did you, Rebecca?
Hello.
I think I'm on the top of a cliff. I dropped it. It's gone forever. My life is over. It even ended the video. No. It's okay. Do you see that cute kangaroo I have there? Look at it. So cute. Alright. You hear them? They're coming for me.
It's logging.
I'm reminded of the Spice Girls song. I want a man, not a boy who thinks he can. Down, 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 down. Come on, Judge, get it together.
I'm calling the matter of Olivia Jackson versus Brett Solomon.
For the record, this matter is before the court on the plaintiff's mother's motion to modify custody parenting time and child support. This hearing is being conducted via Zoom. Present is attorney Deanne Patillo, representing the plaintiff's mother, Olivia Jackson. Ms. Jackson is present. In addition, attorney Amy Woskoviak is present, representing defendant father Brett Solomon. Mr. Solomon is present. Good morning, everyone.
Morning.
The parties have conferred this morning with the front of the court. The court has received the following recommendation this morning from Mr. Walker. The recommendation is that with respect to parenting time, all parenting time exchanges shall be at 6 p.m. The party whose parenting time is starting shall be responsible for transportation. The party shall use app close for all communication if either party requests to use the application in writing. It's also noted that defendant owes $4,796 in past due child support. He shall pay $218 per month commencing October 2024 directly to the plaintiff. The payment of $218 shall be due on before the last day of each month until the arrears are paid in full. Is not inconsistent with this order shall remain in full force and effect. That is the recommendation. And Ms. Patillo, is this recommendation good with your client this morning?
It is, Your Honor. The only thing that's not good with my client is she's going to lose her child care because defendant father has abruptly moved the child to a different school setting. So that's the only issue that's kind of left.
Okay.
But other than that, we do agree with the referee's recommendation outside of the school.
Okay, did you discuss during mediation the issue of the daycare?
We did, but because the child is not actually school age yet, it's not going to be decided. But the child has been at Solt Elementary since she was 8 to 10 weeks old. That's the only school, daycare, preschool that she's attended. So this year, Dad decided he wanted the child to go to another daycare a couple of days throughout the week, but because of the parenting time schedule, my client is going to lose her child care because the child can't go part-time. So my client really would like if the, I don't know if the court would, but we're asking if the court would, allow the child to remain at Solt Elementary and that the school be determined next fall. Because she's just being bounced around. It's not fair to the child, one. And then, like I said before, mom is going to lose her child care. The child can't go part-time.
So mother will lose, is she paid in advance or she lose money? Or she simply will lose her spot in the daycare because they will not take, they want full-time child care?
Yes.
Child cannot attend mom's daycare 2 days a week? They want the child to be there 5 days a week?
Yes. The child has been there since she was 8 to 10 weeks old. She's 4 years old now. So there's really no reason for her to be moved.
Well, why won't the daycare allow, you think that they would allow a child to be there for what mom's got, right now parenting time is 2 days on, 2 days off. Why can't on mom's days, the child go to mom's child care? You're saying child care will not allow that?
My client can speak more if the court would allow, but yes, she was told that they're waiting on the court to make a decision, but other than that, she's going to lose her child care.
So perhaps, so they would obviously permit that if the court ordered, mom could use her daycare on her days and dad can use his daycare on his days. Is there any problem with that, Ms. Patillo or Ms. Wiskowiak?
Yes, the school is actually, because the child has to go the whole week, they're waiting to see if the court makes a decision as to the child remaining at Solt Elementary the whole week, as opposed to her going to Riverside where dad has put the child just here.
But what if the court decides that the child goes to mom's daycare on her days and dad's daycare on his days? Would they accept that?
Ms. Jackson, I don't think so. Ms. Jackson, if the court would allow Ms. Jackson to.
I've already.
Well, again, do we need to have a hearing on this issue? Again, I'd rather hear from the attorneys this morning. So obviously you're saying no, that they will not allow that. Even if you suggest if the court ordered, they're waiting for the court's order. So if the court ordered that, would they permit that? And she's shaking her head no. I mean, she's a lease employer.
I'm sorry, Judge. They're waiting for the court to order that the child remain at Solt Elementary.
Okay. Well, how about if the court orders that the child remain at Solt Elementary on mom's days and mom's days? I mean, that's the court's. What's wrong with that order?
Because the child can't attend Solt Elementary part-time. She has to go full-time. Or
even if a court ordered that, is that your understanding?
Yes.
Okay, and this child's been in Riverside since when? Since September?
Yeah, Sold Elementary from 8 to 10 weeks old, and Riverside, I believe she just started.
Okay.
So, Your Honor, if you'll recall, this has been an ongoing issue from the time that we first started this case, because that was a decision that mom made for the child to go there. We have objected and asked for the child to go elsewhere. And last spring, we had a motion regarding preschool because we wanted the child to go to Monroe preschool. And at that point, the court decided exactly as you just said, which is preschool is not mandatory, and therefore dad can send the child where he wants on dad's days, and mom can send the child where she wants on mom's days. And therefore, my client did exactly what the court ordered. And the court specifically has an order which indicates that it's not going to make a decision regarding school until the child is 5 years old. So we would have already had a hearing on this, but that has been the decision, and that is what the parties have complied with. And it's our position that, I suppose we can have a hearing at some point. I'm sure that this is an issue that we're going to have a hearing about. The question is, when is that going to be, whether it's going to be kindergarten, as the court previously said, or whether we're going to have it regarding preschool, which is not required.
What was the date of that order that you're referring to, Ms. Wiskoviak?
And Judge, if I may, I think the main issue here is that, again, like client would lose her child care, but the child has been in one school, preschool, daycare since she was 8 to 10 weeks old. Even though there may be an order, I was retained May of 2024. Even if there is an order that allows both parents to send the child to whatever daycare they choose, that just happened this year. The child has always gone to Sold Elementary. So there was no reason to move her out of the elementary school that she's been going to for daycare and preschool for the last 4 years. There was no reason to move her.
Okay, obviously the move, I do see the order here.
May 22nd.
2024. Issue of minor children school district is reserved until the child attains the age of 5 years old. The court did not address daycare. So the opinion of this court is that dad's responsibility for daycare on his days and mom's on her days. So maybe mom can find a different daycare. So do we need to add that to this order? And maybe with that, Miss Jackson can get her the minor child, Madeline, back into the Sold Elementary preschool. It sounds like mom wants to do what's convenient for her, dad wants to do what's convenient for him, rather than what's the best for the child.
Well, mom wants what's best for the child instead of moving her to a totally new school at 4 years old.
No, we disagree. We believe that what's best for the child is for the child to go to Monroe, and we've wanted her to do that for a while. We've had this dispute ongoing for quite some period of time. There's nobody lives in Jefferson School District.
My client does.
She does not live in Jefferson School District.
Yes, well, I spoke to my client. Yes, she does. Miss Jackson, we discussed you living in Jefferson School District, right?
Yes, I
You
know.
live right behind Sold Elementary, correct?
Correct.
Right, so she is in the district.
When does the child attain the age of 5? This summer?
June 2025, she'll be 5.
Do you want to schedule mediation? Because it sounds like the court's going to have an evidence hearing sometime in the spring. Do you want us to try to work through these issues, or the parties want a stranger to make these decisions?
We can try mediation.
Well, the court would suggest that before someone requests an evidentiary hearing, whether we should do that in the spring rather than wait till the fall when everyone wants to address school changes. So if the parties cannot agree, then someone should make the request for an evidence hearing sometime early in the summer or in the spring. In the meantime, the court suggests that the parties mediate with Mr. Walker or someone from the front of the court regarding the school issue. But at this point in time, the court's going to simply order that on dad's parenting time, it's his responsibility to provide for daycare, cost and everything, and then moms the days, she provides for daycare. They can choose where they want to take the child.
Your Honor, can I ask a question? When we get to late spring, early summer, would it be acceptable for either Ms. Patillo or myself simply to schedule with friend of the court without filing a motion?
Absolutely. You can reach out to the front of the court. That's what the court would suggest is when you reach out and then spring to the front of the court, whether it's Mr. Walker, Mr. Pratt, Ms. Patrick, Ms. Brower, to schedule mediation with them. And then you can zoom into the court at the same time after mediation, and at that time either put agreement upon record or request an evidentiary hearing. That's what the court would suggest. So absolutely, Mrs. Skoviak.
Okay, thank you.
So the court's going to modify its recommendation. Dad shall address the response for daycare and his time, mom on her time. And the court shall app close for all communication, period. We're not going to have a be party requested application, right? If these parties cannot agree upon these things, the court's going to make these decisions. So all communication shall be via app close. We're not going to argue about it. Someone's requesting it in writing. So Mr. Walker, good morning. If you can just indicate the parties shall use app close for all communication and only regarding the minor child, modify that sentence. With respect to the other issues, Ms. Patillo, obviously your motion to modify custody parenting time and child support, the court does not find that there's a sufficient change in circumstances to modify custody or parenting time. It's alleged that the plaintiff was bullied into this agreement. She had legal counsel. And the court's been all we need to do is address perhaps a more specific parenting time schedule. So it sounds like we have an issue. They got 2 days on, 2 days off. We need to modify the parenting time schedule. That's the only thing before that this court believes may be necessary. Do we need to fine tune this parenting time schedule?
We discussed that issue and the parties decided they wanted it to stay the same, Your Honor.
Right. Anything else, Ms. Patillo, you want to add on your motion to modify custody or parenting time?
No, Your Honor.
Right. Ms. Walker, if you can, I also add the recommendations of the court that denies the plaintiff's motion to modify custody or parenting time. Is there current child support being paid?
No.
Okay, so this simply arrears.
Correct.
Is this amount satisfactory, Ms. Patillo, in terms of $218 a month?
Yes, Ms. Jackson agrees with that amount.
All right, so Mr. Solomon, you got him pay $218. You got 1 week to pay that.
Understood.
These are minimum payments. Let's get this done. I mean, let's not drag us out over the next 10 years. Let's get this done.
Understood.
Why can't you pay more than $218 a month? Why can't you pay $300? $300 is much easier to modify. So the courts can already pay $300 a month, right? We can modify Mr. Walker. Mr. Solomon should pay $300 a month commencing October 2024 and $300 the last day of every month thereafter until the arrears are paid in full. Anything else further this morning, Ms. Patillo or Ms. Koviak?
No, Your Honor.
Mr. Walker, do we have to capture those modifications?
Your Honor, do you also want me to add the verbiage regarding the daycare? Each party is responsible for their own daycare?
Please, yes. Each party is responsible for daycare, location, and expenses on their parenting time. All communication shall be by app close. Mr. Solomon should pay $300 a month for the arrearages beginning in the month of October 2024. And finally, that the plaintiff's motion to modify custody and parenting time is denied. Insufficient change. There's not a sufficient change in circumstances to do so. Okay, the court modified that, and that will conclude this hearing. Everyone can zoom out. Have a good rest of the day.
Thank you, Judge. You have a good day as well.
You're welcome.
What are you bitching about, Judge? I
Okay,
thought
I'm
we
not
were
sure you did. I
done.
put a note in here, Andrea. Is this supposed to be kept in the file?
Yeah, no, I did not.
Okay, maybe you can ask Robin or somebody. I don't know if it's in the file or if that's. You go through.
And they're gone. Okay, look at that. I've already set it up to redirect over to Colin's channel. I'm pretty impressed with the volume I got here on my head. I hope you guys had a wonderful evening. Thanks for trying to cheer me up. I do appreciate it. What else do I have to say? I have to say, remember that I love you. I'm proud of you, and I will see you in the next video. As she looks for the button. Bye.
Ways down and